All right, I think we're set.
All right.
Oh, good morning, Your Honor.
Hello there. Can you state your name, please?
My name is Michael Ford.
Thank you. Do you have a residence, Mr. Ford?
Yeah, 719 West Frontier Street.
Okay. Thank you. All right, how about an email address? Thank you. The state is alleging one count of criminal trespass in the third degree. That's a class 3 misdemeanor. You have the right to remain silent, right to counsel, and right to trial on it. I've scheduled you for a arraignment on the 11th of February at 9 a.m. That's where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge. Depending on how you plead will be what happens next with the court proceedings, and all of those options, as well as the penalty range, will be explained to you on the 11th. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. Do not go near the location of the alleged offense. And then I'm ordering you to pretrial services. So I'm going to release you on your own recognizance as long as you're promised to come to court and promise to follow those release conditions. And also, when you're released, contact pretrial services. So that's the probation department. You're not on probation, but you're on release services. They're going to monitor you between now and the next court date till the case is adjudicated to make sure you're abiding by these release conditions, so they'll give you the requirements. Do I have your commitment to do those things?
Absolutely, sir. Thank you so much for being here today. I appreciate you coming in.
Yeah, no problem. All right, so I'll release you on your own recognizance. If you don't have any questions, that's all I have for you.
I'll see you soon. God bless you. Have a good day.
Thank you.
Yes, sir. You stand right here, using the desk.
Hello, sir. Can you state your name, please?
Sam Jennings.
All right, Mr. James. Got up here. All right, the state is alleging two violations. Both of them are misdemeanor violations. The driving with a suspended, revoked, or canceled driver's license is a class 1 misdemeanor. And an excessive speed violation alleged at 105, I believe. Yes, 105 in a posted 65-mile-per-hour zone. On those charges, you have the right to remain silent, right to counsel, and right to trial. What I'd like to do, sir, since you live in Mesa, is hold an arraignment now with you, and depending on your plea, either conclude the case or schedule your next court date. To do that, I have to get your permission to do this by video and waive your personal appearance. So I'm trying to save you one additional trip back. Do I have your consent to proceed forward with the arraignment?
Yes, sir.
All right, so what you'll be doing is waiving your personal appearance and agreeing to do this by video.
Yes.
So the class 1 misdemeanor, which is the driving on a suspended, revoked, or canceled driver's license, is a class 1 misdemeanor that has a maximum fine of $2,500 plus surcharges, 6 months of jail and or 3 years of probation. The excessive speed violation is a class 3 misdemeanor that has a maximum fine of $500 plus surcharges, 30 days in jail and or 1 year of probation. What I can tell you is there is no jail time being requested at this point of the case. If that changes, your rights will change, but I don't foresee that happening. This case is a little unusual with that speed. Sometimes we see reckless driving also added to the charging that's not in this case. But in terms of that, you're not facing any jail times as now. Your options are to plead either guilty, not guilty, or no contest. The difference between a guilty plea and a no contest plea is the following. If you plead guilty to the charge, you're admitting to the offenses and that you committed the crimes. If you plead no contest, you're not admitting or denying, but you're accepting the conviction. Both guilty and no contest show on a criminal history as a conviction. Your third option is to plead not guilty. If you plead not guilty, I'll schedule you for a pre-trial conference. That's where you meet with the prosecutor of the case. They may provide you the police report and any other evidence they plan on using at a trial if it goes to trial at a later date. At the conclusion of the pretrial conference, one of three things occur. One, the case will in fact go to trial. Two, the case could enter a plea agreement that all parties agree on. Or three, the case could dismiss. Do you understand those options?
Yes, sir.
Okay, you also have the right to hire an attorney. For the court to appoint you an attorney, there must be two qualifications. Number one, you must not be able to afford an attorney. And then number two, you must provide a reason that the state of Arizona accepts as a court-appointed attorney cause. One of those causes would be jail time, but as I informed you, there's not jail time, so that takes away that cause. Some other ones are like a mental disability, so on and so forth. So your options are to provide a reason for a court-appointed attorney, waive the presence of an attorney, or hire an attorney at your own expense. Do you understand that, sir?
Yes.
All right. Regarding the attorney decision, how do you wish to proceed? Waiving the presence of an attorney, hire an attorney at your own expense, or providing the court with a cause for an attorney court at little or no cost to you?
I'm waving.
Okay. What I'll be sending you, sir, is a form that does two things. Number one, waives your personal appearance that we talked about earlier. And then number two, it'll waive the presence of an attorney, so your signature will be required on that form, okay?
Yes, sir.
All right. Before I take a plea from you, do you have any questions about the plea choices?
No.
Okay. How do you wish to plead to one or both of the charges?
Both.
Okay. Go ahead, sir.
Guilty.
We'll enter your guilty plea and we'll move forward into sentencing of the case. That'll save you a trip back to court again.
Yes, sir.
All right, so what I need to do, sir, is make sure that you're aware of the rights that you're giving up by pleading guilty. First off, are you on probation or parole?
No.
Do you have any prior excessive speed violations or reckless drivings on your criminal history record?
Maybe. I'm not sure. I'm not sure.
All right, so maybe on the excessive speed or maybe on the reckless driving?
The excessive speeding.
Okay, so an excessive speed would be that is a criminal offense, not just a speeding charge. Okay, so a speeding can be a civil traffic violation unless it's cited at 21 miles per hour or more, then it would be a criminal. So you might have been arrested or cited and released, which is considered an arrest. Does that help familiarize you with the charging?
Yeah, I was arrested last time. But I fixed my license before, and I'm back to where I was.
Okay,
But
how long ago was that other arrest?
maybe 2 years ago or something like that.
Okay. Okay. And you're not on probation or parole from any of that?
Nope.
Okay. All right. By pleading guilty to the charges, you're giving up the right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt. You're given up the right to have the assistance of an attorney at all stages of the proceeding, including appeal, and that's what we talked about, waiving the presence of an attorney, and I'll send you that form. You're given up the right to have a trial in front of a judge. You're given up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony. You're given up the right to present evidence in your own behalf and have the court compel your chosen witnesses to appear and testify free of charge. You're also given up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also given up the right to a direct appeal. I'd like to make you aware of possible collateral consequences, but first, are you a school teacher?
No, sir.
Okay. Those possible collateral consequences are the following. The possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on your insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in your deportation or being denied citizenship or re-entry. Further on your citizenship is Rule 17.2. If you are not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Understanding each of these rights I've explained to you, wish to waive those rights and enter your guilty plea?
Yes.
Okay. Regarding your guilty plea, are you making that voluntarily?
Yes.
Nobody forced, threatened, or harassed you to make that plea?
No.
Did anybody promise you any lighter sentence or punishment that if you pled guilty, you'd receive it?
No.
Okay. The court will accept your plea and finds that you entered it knowingly, voluntarily, and intelligently. You may file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'll give you a letter that explains that. It'll also explain to you how to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905 once all the terms of the sentence have been completed, and you may qualify for a certificate of second chance and apply to seal the records pursuant to Arizona Revised Statutes 13911 once the terms of the sentence and the timeframes have been satisfied. So I'll provide that letter to you. It'll all be included in one letter. I'm going to review the factual basis of your case that you're pleading guilty to. It indicates that on 1/16 of 2026 at about 8:04 a.m., you were contacted at or near milepost 243 for an offense that occurred between milepost 238 and 251. That violation occurred in Gila County in the jurisdiction of this court, and it's alleged that you were traveling at 105 miles per hour in a posted 65-mile-per-hour zone. In that contact, it was found that your driver's license was suspended, revoked, or canceled, and you are here admitting guilt to those two violations today. Is that correct?
Yes.
All right. I'll be sending you a form that has my initials down the left column of the paper. Those are the rights that I just reviewed with you that you're waiving. That form requires your signature. You wish to give a statement to the court before I impose sentencing regarding the case?
No, sir.
Okay. All right, for the driving suspended license, remember that's a Class 1 misdemeanor that has a maximum fine of $2,500. I'm going to impose $484 and give you the opportunity to get a valid driver's license and produce that to the court. If you're able to do that within 30 days of today's date, I'll reduce that fine down to $202. Okay.
Yes, sir.
The speeding violation, I'm imposing the maximum penalty. $500 is the highest I can go. That's a ridiculous amount of speed, and I'm surprised to not see the reckless driving charge additionally on there.
Yes, sir.
I'm giving you credit for the 1 day served of in custody. There's a $69 jail fee for the 1 day, and I'm going to assign you to counseling, which is a life skills driver responsibility counseling. So that needs to be completed 30 days from today's date. So I'm going to give you a registration form. You can either do it online or request to have them mail it to you, and then you must complete the assignments.
Yes, sir.
There's a court security fee of $35.80. That brings a total balance to $1,088.80. Are you able to pay that today? If not, I can put you on a payment plan.
Yeah, I could do a payment plan. I could
Okay.
probably get it taken care of
Okay.
before the end of
If-
the month.
Okay, so I have to add a one-time payment plan fee of $20.
Okay.
That increases the balance to $1,108.80. How much can you afford per month on that?
Um, I'm hoping to pay it off as soon as I get home, but I gotta talk to my wife. But a monthly basis, I think I could do $200 a month.
Okay. Are you able to make a $200 payment today?
Yes.
Okay. Okay, so what I have, I'll be sent to a judgment and sentencing form I'll be sending you. You're agreeing to pay $200 today and $200 a month thereafter. If you want to pay it all off, there's no penalty or anything for doing that.
Okay.
The next payment is due on February 13th of 2026. You can pay before that if you wish. And that's for the total balance of $1,108.80, unless you get the reduction for getting your license, then that other fine will reduce and it'll be applied. Do you have any questions about anything we spoke about?
Who do I talk about for my car, the car being towed?
So I'm going to release you on your own recognizance, so you'll be released, and then whatever law enforcement agency had your vehicle towed, you may in your property have a copy of the tow receipt there. If not, call that law enforcement agency. They'll be able to provide you the information of which tow company towed the vehicle.
Got it.
Make sure that you come across the street to make that payment. I show that payment today of $200. So we're right across the street from the jail. The jail staff will be able to point their direction that our courthouse is.
Got it.
Do you have any other questions in that?
No, sir. Thank you for your time.
You're welcome. All right, that's all I have for you.
Going back.
Thanks,
want-
Judge.
Send it to you?
Yes, sir, that'd be fine.
Okay.